So sitting down with me is Steve Babin. You're with which firm? Okay, could you hold on 1 second? Sorry. Say again.
Chapin Legal Group.
Okay, and Steve Babin from the Chapin Legal Group. And Steve, you're working on an interesting case that has to do with wage. Tell us what it's about.
Yeah, it's a case where we have sued 30 strip clubs in Ohio for illegal pay violations and civil conspiracy and antitrust violations. It's pretty simple. Essentially, what happens in a strip club is strip clubs either treat dancers as independent contractors or as what they call them in Ohio, tenants. And that's just a way to get away from having to pay them any wages at all. They have to pay a number of fees that are illegal. They got to pay to come in and dance. It's called a house fee or a dance fee. They got to pay a percentage of any individual dance that they do for a client to the club. They have to tip out to the DJ, the bartender, the bouncer, the manager, and by the end of the night, they end up with very little cash in hand. Is what
so
happens.
They're doing. I mean, let's face it. In the context of a strip club, they're doing the work that is bringing people into the establishment, right? I mean, they're the reason why people are there, and they're getting screwed in terms of their payment.
That's absolutely right. They're bringing in the business. There's no doubt about that. That's why people go to strip clubs, is to see the dancers. And in Ohio, it's an antitrust claim. So the antitrust laws basically say you can't unfairly restrict the free market. And with a strip club organization, what you have is you have a Club A that says, look, we're going to pay everyone zero wages, and that doesn't make sense unless all the clubs join together and agree to do it. If you have Club B that's paying wages and giving them extra money, well, then all the girls are going to go dance at Club B, and Club B is going to make all the money. So these guys have agreed to fix the wages, and they do it through what we think is through a strip club trade organization in Ohio. There's one main organization. It's their trade organization, and they audit the clubs to make sure that they're in compliance with not paying the girls any wages at all.
So wait a second. So how does that work? I mean, they all agree to be members of this consortium, and then the consortium goes around and just makes sure that nobody is paying a fair wage to their workers.
That's essentially it. Yeah, they audit other things, and they also maintain a blacklist for any of the young women that want to stand up and maybe ask to, get the same rights that you and I would get under the law.
Has there been any attempt to unionize on behalf of these dancers?
That's interesting. I have a client. Our case is Ohio-based. One of our clients is in Chicago, and she's working in Chicago now, and she has a website. I think it's Stripper Labor Union Rights, and she has tried. So there's been some attempt. The reality of the situation is this is a group of individuals that have very little bargaining power whatsoever. Right, and the strip club pay scheme itself and the culture in which it creates is a system in which the dancers are told they're worth less than the other people's lives. Right, their lives are worth less than other lives. If they were to ask to get protections under the law that you and I would ask for, well, that's probably not going to happen for them. So I think that the culture just within the strip club industry itself is such that the dancers are afraid.
So how did this case come about? How did you get this case?
So there have been a lot of individual, what we call wage and hour cases across the country against one strip club in California, in New York, and Florida, and some of the bigger states. And in Ohio, I had brought a couple, and in investigating those cases and after filing them, found that we had a specific trade organization that everybody joined up and said, let's make sure we do this together and implement this policy together so that we can take advantage of keeping the money in our pocket and not in their pocket.
Do you need, in the context of, there's a couple of different actions here, if I understand it. There's an antitrust violation that you're contending is a state law, or is that federal?
It's federal law. It's the Sherman Antitrust Act.
Okay, and there are state versions of antitrust in some states. I don't know what
Ohio
it is in
has
Ohio.
One, yeah.
Okay, so you could theoretically bring it under both those laws and then secondarily you're also charging that they are misclassified as contractors and are not getting Social Security wages
Well,
right?
they're not getting any wages at all. So it's a claim under the Fair Labor Standards Act, and it's essentially a minimum wage claim. What we're claiming is that in a free market, these dancers would be paid at least minimum wage, and that's what the individual Fair Labor Standards Act cases argue, that you can't classify these young women as independent contractors. They're employees. There's no doubt about it. They're employees. You determine when they come into work. You determine what their schedule is as far as the times they come into work, the days they come into work, the amount they can charge for tips, the amount or for dances, the amount they can charge for drinks, and that makes them an employee. They're not an independent contractor. And if you have an employee, you got to pay them minimum wage at least, and they
Right.
pay them zero.
Are there any other, I guess, laws or statutes or principles, the theories that you're suing on?
So we have Fair Labor Standards Act, the Ohio State equivalent, antitrust, the Ohio State equivalent, and then civil conspiracy.
And what is the civil conspiracy? Is that a sort of an extension of the antitrust issue?
It's essentially an extension of the antitrust issue. It also, I guess the antitrust issue also encompasses the blacklisting of dancers. So they maintained a blacklist. During these audits, if a club had hired a dancer that was on the blacklist, they basically would get a demerit, is my understanding.
Now, wouldn't that be a violation of the National Labor Relations Act too, or is it because they're not unionized? There's no.
That's a great question. I think it would be because they're not unionized. It's probably not a violation of the national.
It's worth looking into. But all right, let me ask you this: in terms of antitrust, do you need to prove that there's a, and it appears that there is a vehicle, but do you need to prove that there is a vehicle and that there has been a mutual expressed understanding that we're going to all treat our dancers in this way, or do you just need to show that there's a de facto sort of situation where all the dancers are being treated that way?
I can prove either, but in our case we have, the first, which is a per se violation.
But you can prove either, but which one do you need, or are both sufficient?
I think both are sufficient, but here we have a per se violation because there are essential elements of the conspiracy that the clubs have agreed to, and those elements are reflected in the contracts girls sign when they come in and dance. Zero wages, you're a tenant or an independent contractor, you have to pay a house fee. There are certain penalty fees if you come in late, if you don't wear the right clothes, things of that nature. And because all the contracts are the same and they all discussed it in the trade organization, it's a per se contracted violation of antitrust laws.
How much, when you look at this, how much is the cases you've seen like Uber implicate something like this in terms of like misclassification, or does it not?
Ask me again.
Uber and those type of like car driving services, how much of what has been established in the context of those cases pertain to what you're doing, at least on the wage side?
Sure. I mean, the Uber case is helpful. The Uber case it's the same type of case. It's an independent contractor case under the Fair Labor Standards Act. I think Uber is a bit more complicated because so the Uber argument is that the Uber drivers they can make their own schedule, right? They can work whenever they want, and that's the strong argument in the Uber case. And the argument against that is, well, the nature of your business is Uber drivers. That's it. That's the only business you have, so they're your employees, right? And in the dancer context, well, we have both, right? That is what your business is about. It's about people coming to see your dancers, and you dictate their schedule.
Right.
So.
So what ends up being the remedy here? I mean, do you break up their cartel? Would the government step in and say, like, we're going to monitor for the next 10 years that there's some type of disparity in the way that you pay, or that you all pay in a proper way, or?
So I think the remedy Well, the first remedy is that you're going to get the dancers paid back minimum wage for every hour they worked, 3 years back, times 2 for liquidated damages. The injunctive relief or the remedy moving forward, we don't know yet. We don't know what the proper pay scheme is that the strip club industry wants to implement that won't violate the law. I think that they're going to have to get together and figure that out moving forward.
Who's your plaintiff? I mean, are they identifiable enough that they're suffering? I mean, I imagine if there's a blacklist, this is the type. Whoever your plaintiff is, would be exactly the type of person who's on that blacklist.
Yeah, so we have a plaintiff that was blacklisted, and then we have plaintiffs that have danced at clubs and been paid no money. And the reality too is, you know, we're not in Las Vegas, we're in Ohio. And our strip clubs, I'm sure we have some nice ones, but we have some not so nice ones too. And these dancers will leave with less than $100 in their pocket a lot of the time. So it's not even a livable wage at the end of the day. So that's really the other violations. They're not making enough money to even live.
And where is the case now? And do you see this as a case that maybe, I mean, is this a problem unique to Ohio?
The case right now is in the Southern District of Ohio in front of Judge Marbley. It is the pay system, I don't think, is unique to Ohio. The conspiracy component and the trade organization may be unique to Ohio. We know that our conspiracy claims consist of members of the Ohio Strip Club Trade Organization. I don't know what other states do. They may have similar trade organizations with similar policies as well.
So it's possible if you guys get a favorable outcome here, we're going to hear about this case taking place in Arkansas, in Tennessee, in Illinois.
I think it's possible.
Interesting.
It's possible.
And when will we have a notion of where this case is going to end up landing?
It's a fairly new case right now. I think it's going to take some time. It's going to take some time, probably a year, before we really know what this case looks like, what the real facts are going to be as far as is it a model that we can take state to state.
Are you looking for more plaintiffs at this point, or do you not need more plaintiffs? Just everybody in that class, you're able now to go forward with the case. You have enough plaintiffs, and in the event that you win, presumably the list of all the people that these strip clubs has that they've employed as dancers, they'll all get some type of notice saying, in the event that you win, you are due a settlement of X number of dollars.
That's right. So we don't need more plaintiffs. I think we have a good number of what we call representative or named plaintiffs, and those are young women that are going to participate actively in the lawsuit. And then when we get a list, we'll send them out notice and tell them your rights have been violated. You're entitled to hopefully a settlement figure of X amount of dollars.
Well, good for you guys. There's certainly people who work in any type of sex industry related jobs have very little leverage, it feels like, and are easily taken advantage of, it seems. All right, what firm are you from again? I'm sorry, Steve.
Chapin Legal Group.
Chapin Legal Group.
That's right.
Steve Babin, thank you so much for your time today. I really appreciate it.
Thank you.
Good luck, guys. Thank you. Sort of a fascinating case, and particularly in the context of how much we hear. There's been like a I guess a renewed push to marginalize sex workers in the Stormy Daniels era, it seems to me.
I feel like after that I should say hell yeah in the absence of Jamie.
I was gonna say, yeah, I am so bummed that she's not there.
Well, and also the activism against, and I'm forgetting the names right now. The anti
Sesta Fosta.
Sesta Fosta.
Well, we're going to be talking. Yeah. In fact, I think our next guest, they're doing some stuff on human trafficking here, and I'm not sure exactly what the take is. And our next guest, she's not going to be here for another 10 minutes or so, and so we'll do a little bit of sound And I mean, it appears I'm still trying to get my arms around like where we are in the context of the Kavanaugh situation. But it appears, I mean, this is what I understand, is that the senators are looking at a report at a secure location today, because God forbid this information gets out.